Chapter 11 is the reorganization chapter most commonly associated with large business bankruptcies, though it's also used by individuals with debt exceeding Chapter 13 limits. For creditors, Chapter 11 cases are among the most complex and consequential bankruptcy proceedings, but they also offer significant opportunities for creditor participation that don't exist in Chapter 7 or Chapter 13. When a business files Chapter 11, it typically continues operating as a debtor in possession. Management remains in place and continues running the business, subject to court oversight and the requirements of the Bankruptcy Code. The debtor in possession has broad powers to operate the business, reject unfavorable contracts and leases, and propose a plan of reorganization. The automatic stay applies immediately and halts all collection actions, litigation against the debtor, and enforcement of pre-petition contracts and agreements. For creditors, the first significant opportunity is participation in the Official Committee of Unsecured Creditors, if one is appointed by the U.S. trustee. The committee is typically comprised of the 7 largest unsecured creditors who are willing to serve. The committee has standing to retain counsel and financial advisors at the debtor's expense, investigate the debtor's financial affairs, review the debtor's operations, and play an active role in plan negotiations. Being on the committee puts you inside the case rather than watching from the outside. The proof of claim must be filed before the bar date, which in Chapter 11 cases is set by court order and can vary significantly from case to case. Missing the bar date in a Chapter 11 case can permanently eliminate your ability to share in plan distributions. Plan of reorganization. The debtor has an exclusive period, initially 120 days, often extended, to file a plan of reorganization and a disclosure statement. The disclosure statement contains information about the debtor's financial condition, the terms of the proposed plan, and the treatment of each class of creditors. You receive a ballot to vote on the plan. Creditors vote on the plan by class. A class accepts the plan if 2/3 in amount and more than 1/2 in number of voting claims in the class vote to accept. If a class rejects the plan can still be confirmed over that class's objection through the cram-down process. But cram-down requires meeting specific statutory requirements. People Locator Skip Tracing assists creditors in Chapter 11 cases by investigating debtor operations, identifying concealed assets, and locating key principles. Visit peoplelocatorskiptracing.com to discuss your Chapter 11 investigation needs.